Melanie Davis to approach the podium.
Sure.
Hi, thank you for coming tonight.
Thank you, Commissioner Durrett. Thank you, Commission.
Will you state your name
Sure.
and county of residence for?
Sure. I'm Melanie Davis. I'm a resident of Buuck County, and I've been asked to represent the Merit System Council for the employees of the Knox County Sheriff's Office in 2 lawsuits that are currently pending in Chancery Court. One involves Officer Dooley, and the other previously involved an officer named Cole. He has since been dismissed from the case, and that is the case that Mr. Moyers referred to a moment ago, where there is a declaratory judgment being sought to declare that, as it is currently constituted, the Merit System Council is not legal and basically would not exist anymore. The reason for that is sort of the background of how the Merit System Council came into being. It originally was created by private act, and that was perfectly fine, but then the state legislature in 1974 established a statewide program for Merit System Councils for sheriffs. Anybody who had a private act like Knox County was grandfathered. When the charter government came around in 1990, however, the private act went away, and instead an ordinance was adopted that provided for the Merit System Council and all of the local rules. Both Knox County and Shelby County have those Merit System Councils created by ordinance, okay, that are not operating under the state statute. The issue has arisen because after 1974, the allegation is that the power to create a Merit System Council was only under the state law. And in order to adopt the state law for Merit System Councils, the county commission of a given county has to adopt that law by a 2/3 vote. Knox County Commission has never done that because it was believed that this ordinance replaced the need for that state law to be adopted. But the law director came forth with an opinion that he believed that the Merit System Council was not appropriately constituted. Therefore, because the law director's office was representing the sheriff who brought the lawsuit in the Cole matter, I was brought in to represent the Merit Council due to the conflict. Subsequently, it became apparent that the county commission was going to need, or the county was going to need to be added to that lawsuit because its ordinance was being questioned. And normally in a lawsuit, if an ordinance is being questioned, whoever adopted the ordinance as a body gets to come and be a party to the lawsuit to defend itself or to state its position regarding its ordinance. Approximately 2 weeks ago, the law director's office answered for Knox County Commission and said, yes, we agree with the law director, the ordinance is not valid. And so that puts the Merit System Council in a difficult position. We still can certainly provide a defense, and I think we have a good one in the lawsuit, but when the very body that promulgated the ordinance says that it's not valid in a lawsuit, it makes it difficult for us to say, no, you're wrong about your own ordinance. It is valid for these reasons. One thing that could cure this would be if this commission did adopt the state law, which is TCA 88401 at SEC, and that's the state law providing for Merit System Councils. And if that were adopted, this whole problem about whether or not the Merit System Council in Knox County is legal would essentially be resolved moving forward. So that's one thing I just wanted to let you know is out there as a possibility. It's also been mentioned by the law director's office as a good possibility to get this resolved. The concern would be that if we move forward with the lawsuit and with Knox County Commission through the law director's office agreeing that the ordinance is not good, if the court agrees and strikes the ordinance, then there is no Merit System Council for Knox County in that case because it doesn't exist under state law and it would not exist under ordinance. So again, we think we have good defenses, but now we're in a bit of a box because of that position that's been taken, saying that, yes, we agree as the county commission that our own ordinance is not good and was not properly adopted back in 1990.
Okay.
Because basically at that point, if you were going to have a Merit System Council, it had to be done under state law because that's what that 1974 law provided as to how to have a Merit System Council in the state. So that's the quandary that we're in. Recently, the Merit System Council had a meeting and decided to no longer have hearings until such time as this case has been adjudicated because they're afraid if they do not have power that they don't want to move forward with that question hanging out in the air to continue to hear cases. So right now, they're not proceeding with any new cases. They're completing a case or two that they had in the hopper already, but any new cases are being postponed until that case can be determined. So that's sort of an update about the lawsuit. I think it would be good if County Commission could at some point look at adopting that state law so that this is no longer a concern. There are different rules under the state law than what are under the current ordinance, and I would think you would want, an explanation of what the changes would be. But there is a way to get out from this problem and to make sure that moving forward, there's no longer a question about the validity of the Merit System Council.
Thank you, Ms. Davis. Commissioner Durrett, is it okay with you if I recognize the other commissioners, or do you still have the floor?
I apologize.
Okay.
I did have a question.
Sure.
A couple of questions for Ms. Davis. Thank you again for that explanation. So when you say that Knox County Commission has in fact agreed that we think the merit system is invalid, what made you come to that assumption?
An answer was, they basically we filed a motion now saying this was not the proper procedure, and that's pending before the court, but they purported to intervene in the lawsuit. They are, I agree, a necessary party. We question whether they should have filed a motion to intervene as opposed to just intervening. And then an answer was filed to the complaint by Knox County that said, yes, we agree with the position of the law director. So there was a filing in the lawsuit that set forth that position. So even if we get through the procedural hurdle that I'm talking about, I have no reason to believe that that won't be ultimately the position that is taken by the law director's office for the county and the county commission.
Okay, thank you. And the reason for that question is because we as a body have not voted to invalidate the merit system at this time. Is that not correct?
I know of no such action by this
Okay.
body.
I just wanted to make sure that Ms. Davis was aware of that. And so you are saying by the answer and the amendment, including the term Knox County, Tennessee, that Knox County Commission is in fact included as the petitioner.
As well, it's now it would be a defendant, because
Okay.
the sheriff's office is the petitioner, and they would have additionally needed to name the county commission because its ordinance was at issue.
Okay, thank you. You may address other commissioners. I want to gather
I'll come back.
my thoughts.
Okay. I'll come back to you. Commissioner Jay.
Thank you, Mr. Chairman. Could you repeat your name?
Melanie Davis, and I'm an attorney at Kaiser & Black in Maryville. And I have a lot of governmental experience.
And you said you're the counsel for the merit system,
Yes, it's the Merit System Council for the employees of the Knox County
which is
Sheriffs.
essentially the board.
Yes, exactly. And that's because there was viewed to be a conflict where the sheriff's office was represented by the law director's office, and then they were suing the Merit Council, which is also normally represented by the law director's office, that if you had the law director's office on both sides, that would be an issue. So I was brought in
you were
as
hired by
independent
who?
counsel.
By the law department?
Yes, David Buuck is who hired me, but I'm independent as far as all of my judgments and decisions. My understanding is that commission authorized that hiring.
Thank you.
No.
Not me specifically,
Yeah.
but hired an attorney for, okay, well,
You
that's
mean-
I'm just trying to understand. So who hired you
David Buuck.
to represent the council?
David Buuck asked me to do it, and I represent
And
the
that is,
council.
I'm assuming, then paid for out of his budget of outside counsel. Would that be it?
I don't know.
I don't know who's paying. I suspect that we are, but I don't know
Okay.
for a fact.
Thank you. I just wanted to start back at the beginning because we haven't all met you,
Yeah, it's okay.
so we don't.
But that's who I represent, and it's just in that capacity. The law director's office still represents the Merit Council on a day-to-day basis in their hearings that they were having before the decision was made a couple weeks ago to stop those hearings. So I just represent them on these cases, not generally, if that makes sense. I'm just representing them in the lawsuits.
Just in the lawsuits, not the grievances.
Not the grievances, that's correct.
Okay, because
That's still the law director's
department
office.
the law director and the law department still would be their counsel as it relates to the grievances,
Yes,
which I know is still a point of convention because they still hired additional counsel when their own counsel, and that, so we have a third counsel now.
I don't know.
Yeah.
Okay. But yes, I represent him in
We
the
have the
two
law
lawsuits.
department, and then we have the counsel that, we have the legal counsel that the council hired when they didn't agree with their own counsel, and now we have a third counsel. So I'm just trying to better understand who's doing what. So, thank you.
I'm just trying to stay in my
Commissioner
lane.
Ward.
Yeah.
So my big question is, who's representing us since we're named in this lawsuit, the commission? Are you representing us?
No, definitely not. It would be the law director's office.
So the law director is suing us and also representing us in response as well.
The law director represents the sheriff and represents the county on both sides, yes.
And then answered for us without even talking to any of us as a representative.
I can't speak to that.
Okay. Can you speak to that? You're unaware.
I'm unaware. I know that the county law director's office represents the county, and all its component entities, in every legal matter that transpires for the county. How this came about, I'm unfortunately not aware.
Okay, so who is aware?
Mr. Buuck,
He's the only one aware.
I'm sure there are other people in the office. This is, remember, I'm recently back, so.
Houston Havstay, I believe, has been intimately
So
involved.
when were we going to be notified that we're getting sued by our own county as the commission, and then when we're going to be notified about answering? Because I don't know about anybody here. Does this come before anybody that we said, hey, we're not following our own ordinances, we don't care? I mean, it's a little bit, I don't know what the right word is, embarrassing, corrupt, ridiculous, I don't know which word you want to use, but there's a couple of them I can think of, and I'm a little hot, so I'm going to take a deep breath and let you guys talk.
Well, I'm going to recognize Commissioner Schoonmaker and Commissioner Durrett, but no, the first I heard of this being stated as the commission, as the opinion position of Knox County, us being the legislative body of Knox County, was when I received a copy of the filings. So I don't know, I understand that county commission is we're not the legal counsel for Knox County, and this is a legal proceeding, but we are the legislative body, and I don't know if it's customary for the law director to state something as the position of the legislative body. I don't know. I'm not a lawyer, so I don't know. Commissioner Schoonmaker, you, and then back to Commissioner Durrett.
Thank you, Mr. Chairman. I mean, the law director's office has the option to hire additional counsel when they feel there's a conflict in-house. And I'm assuming that's what's transpired in your case here.
Yes.
But the law director's office is going to, on any ordinance that we've passed whenever, they're going to defend that. They don't come to commission and say, hey, we want to defend this ordinance, can we have your permission? I don't think I've ever heard of that.
They're not
in
defending
8
it.
years.
They're not defending it. They're saying it doesn't rule.
Commissioner Schoonmaker has the floor.
Sorry.
So, again, we probably need to wait till next Monday when the law director is here present to get these answers.
Commissioner Durrett, we're back to you.
Director Moyers, you were in the law department in the 90s and in the 2000s.
Yes, long time ago.
So in 1990 is when the ordinances were in fact adopted.
Yes.
That created the Merit System Council. So what is your take on all of this?
Puts him in a bad position.
I am an employee of the Knox County Law Director's Office, and I take my direction from Law Director Buuck.
Good. I appreciate your response.
I've been in politics for a while, too.
Right. So Ms. Davis referenced the County Sheriff's Civil Service Law of 1974. Regarding that issue and us adopting it, if we did in fact rule that the ordinances that created the Merit System Council, that we as a body created once we became a charter government, are in fact invalid due to the charter being ruled de facto, because that's really the question, isn't that right? That the validity of the ordinances that created the Merit
Okay.
System Council is because we operate as a de facto charter. Is
I-
that
I-
right?
No, not exactly, I don't believe. As I understand the litigation, and this is my understanding, there is a provision in the charter that says that the county does not have the authority to reduce the powers of the sheriff. I think that only the legislature can do that. The powers of the sheriff are as set forth in the state law. Now, under common law, the sheriff has an absolute right to transfer or terminate. Tennessee is an at-will employment state. In the absence of a merit council, the sheriff would have the absolute power to terminate, transfer, do whatever he wanted with any employee, just like any other private employee would have the right to do. When the charter was adopted, there was a provision in the early part of the charter that basically says that all private acts that apply to Knox County are repealed. And then those private acts were replaced with ordinances. The question that arises here is when the county commission or when the charter adoption repealed the private act and then the county commission passed an ordinance, was that an act by the county commission to limit the powers of the sheriff in a way that's repugnant to that provision of the charter that says that the county commission cannot limit the powers of the sheriff's department? That's where the issue comes. And I think she's correct. That's my understanding of the
And
question.
the issue about the power to enact it at all, given the 1974
Right,
law.
and exactly.
Yes.
That once the private act was extinguished by the charter, that if we wanted to carry forward a merit council, what this commission should do is adopt the 1974 Merit Council Act by 2/3 vote, and that would make the whole question go away. And I believe that that's what the Merit Council would like to see happen. Frankly, I think, as I understand it, that's what the Law Director's Office would like to see happen, is do that to put the act or the Merit Council on a good, solid legal footing so that it could not be changed or questioned going forward.
Okay, thank you. The reason for my question is because we have, in previous commission meetings, been told that in Jordan versus Knox County in 2007, when it was ruled that, yes, in fact, we have been operating, I don't want to say illegally, but yes,
Is a de facto.
we are a de facto charter, and therefore we are a de facto county commission, and all ordinance that have been created since then are in fact de facto. I can read you the summary if you would like.
It's okay, go ahead.
But, so then, my question then becomes, if that is the actual reason, and we do declare the Merit System Council invalid, wouldn't other ordinances, such as the term limit amendment that was also a part of Jordan versus Knox County, also be considered invalid?
Well, okay. First of all, this is way more in the weeds than I was ready for. My understanding is after the Jordan case was ruled on, the county set to work fixing the charter by the adoption of several charter amendments that actually established the offices that the chancellor found were the reason that the county was lacking. I don't know that it's been challenged, but I believe that in enacting those ordinances, we went from being de facto to being de jure. At that point, I think that the county would address all the issues that the chancellor found to be wanting. So I don't think that as we operate today, we would be considered a de facto county. Secondly, the term limits provision was enacted not by the county commission, but by vote of the people of Knox County. It was an amendment to the Knox County Charter. So it stands in a completely different situation than the adoption of an ordinance as we're talking about here.
Commissioner Smith.
Thank you, Mr. Chair. I want to make sure I have this part correct, because John said that the law department defends our ordinances. In this case, they're not defending our ordinance. They are saying that our ordinance is invalid.
I haven't seen that amendment, and honestly, Commissioner, I can't answer it. I wish that I could,
Okay. Can you answer
Commissioner
this?
Buuck, or Law Director Buuck,
Is it not normal to give knowledge to those named in a lawsuit? And I'm wondering if anybody here had been given knowledge that the commission had been named in a lawsuit. And I have a question for you.
Sure.
You're saying now that the Mayor's Council's solution is for us to adopt the 1974 Act?
That's one of the solutions, yes.
It's one of the solutions.
Yes.
What are the other solutions?
Well, one other solution might be if the law director's office were to get separate counsel for the county commission. I don't know if they would take a different stance in the litigation, but that would be something that would take a long time to determine. And meanwhile, the Merit System Council is idle, as we discussed. It would be expensive, and in the end, you might get back to the same place where you would be anyway, adopting the state law. So,
Well, the law department brought an ordinance to do this, and we were unsure here on commission. We asked for an attorney general opinion, and we were informed that the attorney general would not be able to give us an opinion if there was pending lawsuit.
okay.
You say there are things that are different between the 1974 Sheriff's Merit Council Act and our current rules?
Yes.
Could you please give me, because we were told there was no difference.
There are just particular differences. I would need to go through and list those and compare the two, but they are not the same.
Can you highlight what the major difference is?
Just some of the procedures as far as who does appointments, who is the chair, how the chair gets appointed, those types of procedural things.
All right, thank you.
Commissioner Bustler.
Thank you, Mr. Chair. I remember a little bit about when Law Director Buuck brought the solution to this problem to this body. And it said we would do away with the present, if I remember correctly, and I sat down in his office, I wanted to make sure it was true, and this is from memory, it said, if we would have done that and accepted the 1974 solution, which he had as a resolution before us, this would go away. And we decided we wanted to hear from somebody else because we didn't think that was right. But you're saying that was right, correct?
It is right, as long as you understand, and I would maybe like
Yeah.
to chart out the differences so that
Yeah.
they were transparent, but yes, that would solve this problem.
And we decided no. You remember, we wanted to get somebody else. So we're here now that our law director gave us a solution to take care of the problem that we're having right now. And it's costing us money every day that we do that. And that could have been taken care of some time ago, is what I understood. And I sat down, I don't know if any of you went up there and sat down and talked with David after we had that situation before us to find out what it was about. It was kind of confusing when it was here. And he sat down and explained it and showed me those different things that was going on there. It may not be a legal matter. I went, wow. So we had this one way to do it, and I thought, well, so I just left it alone because it was convoluted to me. It was hard to understand that you had to do away with it to get it.
Yes, you would need to repeal the old ordinance and
And to
adopt
do
the
the-
new state law in its
Well,
place.
the old state law. Well, the
Well,
70
it's new, adopt the 1974 law, yes.
So we had to do away with what we had to get the old one, and it would have taken care of the problem. So that's where we're at, really. If you really think back on it, that's what we discussed then. Thank you.
Commissioner Ward, back to you. Certainly, Commissioner Schoonmaker, would you like to
Thank you,
respond?
Mr. Chairman. That was in November of this past year was that November he brought that to us, or December?
I believe. December.
December
I believe so.
meeting, and then he pulled it because people didn't want to do that, yeah.
Commissioner Ward.
I don't disagree with you, Commissioner Bustler, and you know, I wish we had a more in-depth talk about this. The part that I'm fine with creating a solution if we have a solution at hand, that's great. The part that I don't like is somebody answering, our own lawyer answering for us without defense of us is the part that I have a problem with. not whether we should adopt it or not adopt it. That doesn't matter as much as, that's the part that does not sit right with me, is you're suing us and then answering for us, and in a sense, to weaken our own defense of ourselves, which is just kind of like, it's like if me as a business owner be hiring a lawyer to sue me and then also defend me, but when he goes to defend me, he then goes and says, well, hey, we don't believe in our defense anyway, so don't worry about it. And then I lose the lawsuit because my own lawyer, that's how convolutedly crazy that is in my mind. That being separate from this mayor council in general, my opinion, that's why I put on public record, is we should probably, this thing has been a disaster since I've been on commission. It's probably one of the worst things we've had to deal with, and it's just such a mess. I have a personal opinion that we should just make this mayor council a subcommittee of commission at one point in the future. I know that's not gonna happen right this second, but that might be the best solution, is to eventually just have this another subcommittee like our other subcommittees. I have 3 to 5 commissioners appointed to it every year when we do our appointments in September, and it's dealt with that way instead of, it's been such a political disaster getting people to serve on here and all the lawsuits that are, and then we have all these kinds of issues where we're not defendable and there's all these questions about it. If it's a subcommittee, it makes it a lot more clear cut and at least a lot more easy. The people that be serving on it are already been elected by the people that serve in the best interest. But that might be a best solution going forward, but besides that, that's all I want to say.
Commissioner Bustler, did you want to respond?
Yes. The way it was explained to me, Mr. Ward, and like I said, I'm not a lawyer, so bear with me here, that this had been going on before David Buuck, or Law Director Buuck, was elected to office. When this came up, he went back and researched all of this. But in the meantime, the Merit Council wanted to sue the law director because he was not going on with this litigation because he felt there was something wrong with the act itself. He found out what that was, and he wanted to correct it. But since they're part of the county, the Merit Board, and you know, people come up here to ask, can we get a lawyer? And the only one that can supply a lawyer for those different departments is under the charter, is by the law director. He is the one that hires lawyers for the county. So they wanted to have that lawyer, and they're spending more taxpayers' dollars for doing it. And so if a department comes to this body and says it wants a lawyer, or I think the only one that can hire a lawyer for those departments is the law director, not even this county. We can, as a body, can hire a lawyer without going through the law director, but no one else can in the county. I understand that. Is that correct? That's correct. So there's where you get the convoluted things when they come and ask for a lawyer and you tell them they don't need it because we'll take care of an act. And they won't listen to you because it becomes passionate and becomes political. And so what we're doing now is we're sitting up here talking about it, and we're wasting taxpayers' dollars every day that we do this. So we ought to do something when it comes back and take care of it as soon as we can, so this doesn't happen again. So that's the way I understand it. Thank you.
Commissioner Daly.
Thank you, Mr. Chair. Ms. Davis,
Yes.
my understanding is the policies and procedures are by the Merit Council Board.
Yes.
So how would that differ from the state?
Just the way that it's set out is there are differences. There's actually more power for the Merit System Council under state law than there is under the ordinances.
So the way to really solve this is for you to get together with the law department, work out to adopt the 74 Merit Council, and it's done, like we wanted to do back in December. It's all set it up. So it seems like it's simple to do. Why don't we do it?
I will be glad to do it.
It's just, we know what to do. Let's just go ahead and do it.
All right.
Commissioner Hill, before we go back to Commissioner Smith.
Thank you. Thank you. If we were to take this action, really addressed to both of the attorneys, what does that do to the actions that the council have taken prior to
Sure.
the time we adopt it?
Sure, that's a great question. I think the same like de facto argument that you had in the prior case involving Black Wednesday would apply to those types of cases. And I don't think that we would necessarily get a ruling from the court one way or another in the lawsuit. I would suggest that it should just be dismissed and dropped so that there's not a final decision on it. And then, you just take the position that whether the ordinance was legitimate or not, de facto those hearings were done by a de facto board, and that the results remain in place just like they did for county commission. Do you agree, Mr. Moyers?
I agree.
It would be a similar concept. So I don't think that it would upset the entire apple cart because of that de facto argument.
Back to Commissioner Smith. Yes, sir.
Thank you, Mr. Chair. Okay, I'm not a lawyer. Don't play one on TV.
Okay.
So someone tried to explain this to me. If we go back and we adopt the 1974 Mayor Council Act, everything magically goes away, or just this one single lawsuit about does the Merit Council actually exist? It will have nothing to do with the plaintiff's lawsuits, will it?
Well, what I would envision, we'd have to negotiate this, would be that county commission would repeal the prior ordinance and adopt the new act. I don't know which would go first, but one of those would happen at the same meeting as the other. And then the lawsuit would just be dismissed, like I said, prior to there being any ruling. It could just be,
Okay, but that's the singular lawsuit.
That's the singular lawsuit, and it only deals with the Merit System
Right.
Council. That's
but,
all.
But it won't do anything for it. And correct me if I'm wrong, one of the lawsuits is, does the Merit Council, can this be heard? Is that being filed because the Merit Council doesn't exist, or because the Merit Council rules?
It's being done because there has been a question raised in a lawsuit about whether or not it is properly constituted. So the Merit Council just decided, in order to be conservative, that they wanted to stop having hearings until that issue was determined. Just because in case it turns up that after this came to their attention, they still continued to have hearings, maybe that would be a problem with the whole de facto argument.
How many lawsuits are there here? There's this one lawsuit about whether
No, there's a
Merit Council
lawsuit
exists.
Duly.
about whether or not, there was a lawsuit about whether or not it could be heard according to, did they follow their own rules?
Right, and that's been ruled on, right?
I can't keep track of all the lawsuits these days.
Okay, so yeah, there is a lawsuit with Ms. Dooley, and it is proceeding, and then
I
there's the
thought
Cole lawsuit.
Chancellor Haggerty said that could move forward.
I have a supplemental question to Commissioner Smith, if I can jump in. Is that okay?
It's a supplemental question? I'm still looking for my answer.
Okay, I believe that, now that I think about it, I still helped the Merit System Council with Dooley, but I believe it actually was dismissed. It's just subject to being brought back up after the proper processes are followed, and I would be representing that.
So really, the only lawsuit this would affect if we adopt this is the lawsuit on whether the Merit Council is de facto or not.
Yes, and there was, like I said, a fellow named Cole who was involved in that lawsuit initially who's been dropped, so we'd have to look at how the whole thing would impact his case because his case was heard under the ordinance.
Mm-hmm.
So we'd have to figure out how his particular situation would be dealt with in a compromise like this.
It's good enough for me, Commissioner Jay. You can proceed.
Thank you. I'm going to add some more mud to the clarity factor. If there's a current lawsuit that is before Haggerty.
Yes.
That it is all about, does this exist in real form or not? Is that a plain?
Correct. Yes.
Okay. Let's say he says it isn't.
It isn't existing legally.
Correct.
Okay.
Let's say the ruling comes out and goes, this was never done right from the beginning. This is a non-existent thing and whatever. Does that mean that all of the current pending grievances then go away because those would all be grievances against something that doesn't exist?
Potentially, that would be what would happen.
Okay. Let's say this body decided to, having not fully read it, we're talking about a hypothetical 1974 structure.
Yes.
Let's say this body had said on Monday of next week, we want to adopt the 1974 and we deem all other ordinances having anything to do with this world, adios. Would all current pending grievances then go away, and we would start all over with a brand new slate, brand new officers, brand new structure, brand new staff. We would literally reconstitute this from zero.
Yes, you
So-
could appoint the same people that you have now,
We
but you would
could,
have
but
to
we could
go.
also not.
You
But
could also
we
not.
could say, we want to take the 1974 agreement, we want to start all over. Thank you very much, staff. We will get back to you if we require your services. Thank you very much, council members. We'll get back to you if we want to reappoint you. We're going to start back at zero, and we're going to go, this is what we want, or this is what we're going to adopt as our Knox County protections for our officers.
Yes, you would start over with the state law. Now, what happens with pending cases, we would have to, again, look at that.
That is the biggest question. 'Cause
Yeah.
we have currently 3 grievances, I think, that are in perma-hold, right? Is that correct? We have 3?
I believe that's
Okay.
correct.
3 that are sitting in la-la land. I believe a lot more than politics than legal structure, but those have to, those are real cases from real officers that are sitting in this sort of middle ground. So I would formally like to request a copy because I looked up 88401 and it has about a 2-word description. I would like to see the 1974.
Sure.
And I would also like to see the resolution that Director Buuck sent us in December resent to us for review.
Sure, and it's 401 through 419 of that TCA code. The 401 is just like the title.
I just couldn't find
Yeah.
it with a quick
Yeah,
thing.
but
If I could get, whoever wants to
Yeah.
give me those 2 things, I'd like to see the resolution and then the 74. And then, Mr. Moyers, I would like to ask the question of our lawyer. If we did adopt that, what would be the procedures for the Merit Council board members, the grievances that are pending, and the staff that currently works for Knox County?
Well, I agree with Ms. Davis that the commission would have to appoint members of this committee and the staff. Now, my understanding is what we want is for basically everything to stay the same. We just don't want the Merit Council to be able, I guess, subject to collateral attack based on this question of whether or not it was properly constituted in the first place.
Well, I'm not sure this body wants to have it be the same. This council and the structure and the way it's set up, we've had multiple discussions. This all happened, I think, before everyone that was here. It was, put in place well before all of our time. We've had discussions last year. We had a budget discussion. Who authorizes payment and raises? Who oversees the staff? Who determines the rules of the council? We know how the appointment process, there's layers upon layers upon layers that we're just, all of us have sort of looked at each other and said, who's responsible for what? We've talked about, do the staff nest under the mayor's office, and that was talked about. We've talked about, do the council, of course, we had some ordinances that I proposed that some that didn't fail about expanding it. I'm not sure we want everything to be exactly the same. I think in general, this body has constantly expressed a commitment that we want a fair process in which our officers have a process in which to file grievances according to a certain set of rules. But I think that I feel like there's a lot of ideas of how we can make it better, because ultimately we want a system that protects our officers. We want a system that's fair, open, transparent, and is without question, without politics. That's how it all started, 50 years ago, and I'm not sure we're there today. But that's just a commentary. I think we've got a long way to go to get there, but in the short term, I'd just like to review kind of what are our options on this.
We'll get that to you.
And a site map might be helpful as well of what lawsuits are who and who represents who, a general, like, who's in the game, that might be helpful as well.
Mr. Schoonmaker.
Thank you, Mr. Chairman. Ms. Davis,
Yes.
so at the present time, it is your recommendation that this body should consider adopting then the County Sheriff's Civil Service Law of 1974?
Yes,
Okay,
but
thank
it
you.
has to be done by a 2/3 majority, so we just needed to make sure that it had that support.
Commissioner Bustler.
Thank you, Mr. Chair. The one big thing that I think, when you all were talking, came back into my mind, by doing what we're supposed to be doing, well, you do have to do away with the council, but you can reappoint it just
Yes.
like it is. And that was the big, scary part of this for the protection of the officers. So, we can't guarantee how everybody else is gonna vote on here if it goes back. So that's the scary part for the merit council and the sheriff's office.
That's
there.
right. There's no guarantees that it would revert to the way it is
And
now.
there's 11 of us, and sometimes we can't even agree on what we want to eat for lunch at night or when we have those stuff. But what we've got to do is assure the merit council, the sheriff's department, the sheriff's employees, that we want to protect them and we're going to do what's right to protect them and to give them, and this will give them more power. Will this not give the merit board a little bit more power?
Yes,
My understanding,
yes.
Okay, so
Mine
it
too.
would do that. And how are you going to assure them? I don't know, until we step into it, take care of it, and put the merit council back out what they're supposed to be doing. And I hope we do the right thing from here on out, but that's what's going on right now. We've got the merit board that can be sued either side. And again, we're still spending taxpayers' dollars and by not acting on this as quickly as we can. Thank you.
Mr. Smith?
Thank you, Mr. Chair. If we adopt the 1974 Sheriff's Merit Council
It's a
statute,
mouthful.
civil service, put an acronym on it. Does it have a specific set of rules that we could not variate from?
Yes.
So.
It's
as-
not a situation where you can be all creative. Like,
Okay,
you can be much more creative with an ordinance than you can with state law.
Right, so as Commissioner Jay is saying, we would not be able to, we would have to follow that state statute
Yes.
as it's written.
Yes, and you would have much more structure than what you have under an ordinance.
Okay. As to the grievances that are currently in the pipeline, I would imagine those they would have to go away and be refiled.
That's one option.
Is there any liability for the county for due process and making someone go through this for this long and then saying, hey, you got to start over?
I'm not aware of any.
Okay. All right, thank you.
Commissioner Hill?
I may muddy the water too. It seems like there was and again, I noticed Miss Oyster is sitting back here, and she may need to address this, that there was a document going around that that stated, contrary to if we adopted the 74 ruling, that they would have more power, when in fact the statement was that that is not correct. In fact, they would have less power and less ability to protect our law enforcement. Did anyone else see this? Am I the only one that saw this? Was something like that put out, Gina?
She said it wasn't by the merit council.
And it's, so the one put out by the law director's office?
Are you talking about the statement that was made on behalf of the,
Ms. Osher, do you mind to come to the podium? Thank you.
do I need to state my name and?
Please.
Gina Oster, Knox County. Are you talking about the statement that was made by the law department? There was a few statements going around, I think, by the law department, the sheriff's office, and that kind of stuff.
What I recall hearing is that if we were to adopt the 74 ruling, that in fact, which the sheriff's department maintained, would actually give the board more
Give him.
authority. And it was, because there's so much mistrust going on, it was believed, and I thought that came from the merit board, that that in fact was not true, that there were specific items that would be lost to the merit board that they currently now are able to do.
I think that there's a lot of misunderstanding about the whole situation. There are more powers that are given in some aspects of the 1974 than what we have currently right now. There could be some other things, which I think Ms. Davis is going to be able to give to you guys maybe next week, if that's what you want to do. So I think that's kind of where we are, trying to figure it out. I don't think, and I think Paula said, we didn't send anything from the Merit Council. We really just tried to go through Ms. Davis and just tried to figure out where we're going, and that's why I made the decision last week as the board that we just stop all hearings and stop everything right now, because we're in this limbo. And with lawsuits being filed at us at rapid pace, it's kind of hard to know what to do and what not to do. And so Ms. Davis gave us legal counsel, and it's probably better to go ahead and just sit tight right now until we can figure out what's happening. But I do know that 1974 is going to give us a little bit more power. It may possibly give the sheriff, maybe it's interpretation, and I think law is a little bit of interpretation of everything, Mr. Moyers, but that's kind of where we are. So we're really just seeking our legal counsel and trying to just figure out what's best for merit right now, what's best for our officers.
And who is the plaintiff in this lawsuit?
The sheriff.
All right, so the sheriff could also drop it.
Sorry?
The sheriff could also drop the lawsuit. I mean, what we are is we're just sitting here in the middle of a power struggle.
If the commission adopted the 1974 law, this lawsuit would be moot. So
I would love for everybody to drop it, because I've never had my name in the courts before, and it's all over the place. So, yeah, you can Google me and find it all over the place. So I'm happy with dropping the lawsuits altogether.
I think what you're going to find if you compare the two, the 1974 and the ordinances, there's going to be some give and take. So there'll be some more powers on one hand and then some given away on another. So I don't think it's necessarily a situation where it's just more power or not. There's going to be more power in some areas and taken away in others. Yeah.
Commissioners, I hate to say this, but we have two more discussion items on our agenda, and we have other lights on. And at the moment, I am the only chair or vice chair on this dais, and if we don't take a break, we're going to have a bigger problem than what we're talking about. So let's take a quick break. We'll reconvene at around 7:30.
Thank you.
Call this work session back to order. We are still on discussion item 46 regarding the lawsuits facing the Merit System Council for the Sheriff's Office, and I believe Commissioner Durrett, your light is on, and so I'm going to turn the floor over to you.
Thank you, Mr. Chair. I just want to remind my colleagues that, we have this discussion about lawsuits and grievances and all this, but it's not just about that. Merit system, especially the staff, is what has created the hiring process as well for the sheriff's employees and the merit-covered positions. And so we need to keep that in mind when we're talking about this and talking about if we get rid of it and all of those things and the potential that we could potentially get rid of 4 livelihoods of the staff members that work for Merit System. So when we need to tread carefully as we go through this. It is a very sticky situation, as we have found out, but at the same time, people rely on this for their livelihood. This is their job. I have not reviewed the 1974 Act well enough to know, and I know when it was brought before us before, in December, I believe, there was a particular question that sticks out in my mind because I was worried about our executive director maybe being able to be demoted or even lose her position, because it said, and I am recalling from December, so this could be incorrect phrasing, that the sheriff would be able to choose a secretary. And at the moment, the secretary is in fact the executive director, aka Paula. So again, I just want to remind everyone that this, while maybe it sounds simple, I don't think it's as simple as we want it to be when we look at this. Thank you.
Thank you, Commissioner Durrett. Thank you, Ms. Davis, for your input. Thank you very much.
And I've just been informed by Mr. Moyers, I don't want to misrepresent anything, but he believes that it was not Knox County Commission.
I'm sorry, if you don't mind to just speak into the microphone and
Sorry.
have the last word, please.
Mr. Moyers was just informing me that he believes that, according to David Buuck, it was the county that intervened and not county commission. My understanding was that it was supposed to be county commission because that was who was going to, stand up for its ordinance potentially. But if I'm wrong about that and it's the county, then that was a misunderstanding on my part.
That's what David just told me on the phone. I haven't seen the filing,
Okay.
so I just don't.
Okay, so if it were the county, then I apologize for telling you it was the commission because that was my understanding.
Thank you, Ms.
I
Davis.
didn't want to tell you wrong information.
Thank you. Commissioner Durrett, did you have a
And
question for
Ms.
Ms. Davis?
Yeah.
Just more of a request, and I think everybody would want this. Would you do us a favor
Sure.
and do a comparison between the 1974 Act and the current merit system as it is right now, so we can see the similarities and the differences if we were to, in fact, pass the 1974 Act state law?
I would be glad to do that.
Thank you very much.
Okay, thank you.
Thank you, Ms. Davis. Madam Clerk, would you please read the next, I'm sorry, Commissioner Ward, your light is on? Mr. J, your light is on.
While I also want to see the comparison, I don't think we can direct Ms. Davis. She doesn't work for us. She works for the law director. I don't think we can give her instructions and decide to spend her time and the taxpayer monies she's not at our direction. So while I would like that, I'm not sure we can do that.
Well, I didn't take it as a directive, but Ms. Davis, would you like to respond to that, please?
Mr. Moyers, I don't know. I just don't want to circumvent this council does not work for Knox County Commission.
Okay, here's the way this works. Once we hired Ms. Davis is out of, we do not supervise her. She
Correct.
works for the Merit Council. So she is not under anybody's direction but theirs.
That's correct. But I would be glad to, in representing my client, provide that to you because I feel like it's in their best interest for you to see it so that you have the information necessary to solve this problem. So I see that within the scope of my representation to provide that information to try to get this matter resolved. Okay. And then I'll be glad to share that with the law director's office, and if they differ, they can let you know with my interpretation. Okay.
Thank you, Ms. Davis. Commissioner Ward, did you have a question for Ms. Davis? I'm
Sorry,
sorry to keep you running back
last
and forth.
question, and then I promise. So we in court have already said that we don't believe in this ordinance. If we don't accept this, are we just without anything at that point to clarify?
It just makes it difficult
Okay.
for me to come in and defend an ordinance when the body that passed the ordinance says it's no good.
Okay.
And or the county that has the commission says it's no good. It's pretty much the same thing. It makes it much harder. Not impossible, but much harder.
Thank you. Thank you again, Ms. Davis. Madam Clerk, please read the next discussion.